Many people are surprised to learn that they have an estate plan. And they say, how can I have an estate plan? I didn't see an attorney. I didn't fill anything out. Well, you have the state's estate plan. For example, the state of Washington, they have to have rules and laws for what to do with you and with your assets. So there is an estate plan in place for you, even if you are completely unaware of it. For example, you pass away and you don't have a will or a revocable living trust or any other kind of trust, where do your assets go? Well, there needs to be an analysis. If you are married and everything that you have is community property, it all goes to your spouse. So the state isn't trying to take away things from you. They're trying to figure out what would you have wanted. Or let's say you are a single person and you've got 3 kids. Your assets get divided equally among your 3 kids, even if you wanted everything to go to 1 or 2 of them because the other one you're estranged from. The state has a plan, and that's to divide everything equally. So the state, sometimes people get concerned. They say, oh, the state's going to take everything. No, if you die what's called intestacy, without a will, the state's going to try to figure out what would you have wanted. Obviously, they don't get it right if what you wanted isn't what the laws of intestacy provide for. But you do have an estate plan for what happens to your assets upon your death if you have not put into place your own estate plan and if you have not directed where those assets go. One other thing, people when they think about estate plans, they're always thinking about, well, what happens when I die? I have to tell you that as an elder law attorney, we are very aware of what happens when people become disabled, incapacitated during their lifetime. And nobody likes to think about that. Nobody likes to think that something's going to happen to them such they can't manage their own financial and personal affairs, but it does happen. We all know that. As an estate planning and elder law attorney, we are going to definitely work with our clients to get in place durable powers of attorney for finances, for health, healthcare directive, also known as a living will, to make sure that that person's voice will be heard no matter what happens to them during their lifetime. For example, if they become incapacitated, all of those documents make sure their wishes are known, people whom they trust will be making decisions for them, etc. What's the state's plan for you if you don't have those documents in place and you become incapacitated, unable to manage your own affairs? The state will have control over your affairs through a guardianship, conservatorship proceeding, which is in the court. There will be someone appointed to be your guardian, your conservator, to manage you and all your financial affairs, subject to the approval of the judge. All actions are subject to the approval of the judge. Your personal care plan, your financial plan, what assets can be sold, what can't be sold, on and on and on. And that costs money, which you pay for through your assets, through your estate. It's all very public in that, a detailed personal care plan is filed with the Superior Court where you live about what your life looks like and who's in charge. It could be a family member or it could be somebody you've never met. So that is the state's estate plan for you if you don't have those necessary living documents in place. So be aware you do have an estate plan. It's either one that you want and you chose and you're comfortable with, or it's the default plan of the state.